The name you have on the case and who I am, it's two different people.
You want to smile about it and laugh about it? Take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. I'm not threatening you. Say one more word and that's contempt. 30 days.
It's a confusion.
I've stated multiple times on the record that I wish to represent myself.
And there it is, the first warning from the judge. What's striking here isn't just the tension, but how quickly it escalates. The judge isn't being emotional, he's establishing authority. In court, a single smirk or laugh can be interpreted as disrespect, especially after being told to stop. This defendant, though, seems to treat the courtroom like a stage for rebellion. What sovereign citizens don't realize is that contempt of court is a real crime. When a judge says 30 days, that's not a bluff, that's jail time, effective immediately. It's wild how many of these cases follow the same pattern: defiance, denial, and disaster. Question for you guys. Do you think the judge handled this too harshly, or was he right to shut it down early?
Well, I thought we got rid of that issue the last time.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days.
Here, we see the defendant double down on one of the most bizarre parts of the sovereign citizen belief system, the split identity myth. They claim the name in all caps on legal documents refers to a corporate fiction or straw man, not their real self. But legally, that argument has zero merit. Courts don't recognize alternate realities. They deal with individuals who commit actions. What's interesting is how patient the judge remains. He continues trying to guide the defendant back to logic, giving him every opportunity to respond like an adult. But every moment wasted on pseudo-legal nonsense only hurts the defense. Imagine standing before a judge who could show leniency and instead you choose to antagonize him. That's not strategy, that's self-sabotage.
Or before the court, you have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
this is under the assumption that you're compelling me to identify as Thomas York Steyer, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back, maybe. I'm not threatening you. Say one more word, and that's 30 days.
The judge's patience finally runs out, and it's completely justified. Contempt of court is one of the few tools judges have to maintain order. Without it, chaos would reign. This defendant was warned multiple times, but he kept pushing, likely thinking he could expose the court as illegitimate. Instead, he exposed his own ignorance. What's amazing is that he still acts like he's the victim, claiming the system is fraudulent. But here's the truth. The only fraud is the belief that you can outsmart centuries of established law with YouTube conspiracies. So I want to ask you, if you were the judge, would you have stopped at 30 days or doubled it?
When you were before the court on a felony complaint that does allege count 1, and I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges.
I'll have a
Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will.
This section highlights one of the most misunderstood parts of courtroom procedure, self-representation. When you represent yourself, the court treats you exactly like an attorney. That means no special help, no leniency, and no "I didn't know that" excuses. The judge explains everything: charges, rights, discovery, and the implications of proceeding without counsel. Yet, instead of listening, the defendant throws in irrelevant buzzwords like trustee, fraud, and social security number. These are all common phrases in sovereign citizen circles based on misreadings of maritime and trust law. It's almost tragic the judge is spelling out his rights, but the defendant is too trapped in his ideology to hear them. The result? More trouble, more time, and absolutely no progress.
Set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has some discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your language.
You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're presuming
You will
jurisdiction
learn
of the
how
defendant.
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this
You
institution.
have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not.
And that's where this chaotic hearing wraps up a perfect example of what happens when delusion meets the rule of law. The judge did everything right. He explained the charges, upheld courtroom order, and gave the defendant every opportunity to comply. But the sovereign citizen refused to play by the rules, earning himself 30 days behind bars and a long road ahead. This case isn't just about one man, it's about the growing clash between reality and conspiracy. Courts aren't playgrounds for ideology. They're institutions built on order and accountability. So, what do you think was the judge too harsh? Or just doing his job? If you found this breakdown as wild as we did, make sure to like, share, and subscribe for more jaw-dropping courtroom moments and expert legal commentary. Your support helps us keep exposing the truth behind viral courtroom chaos.